Good evening, ladies and gentlemen, lords and ladies, and welcome. I'm John Armour, the Dean of the Faculty of Law, and I'm delighted to introduce our lecturer this evening, Professor Iyiola Solanke. I'm so thrilled that there are so many of you here this evening. Tonight is Iola's inaugural lecture as the Jacques Delors Professor of European Union Law, the chair established with funding from the European Commission. Iyiola read German and drama before doing her graduate study in law at the LSE. Having completed her doctorate, she joined the law department at UEA before later moving to Leeds University Law School. She was there made Professor of EU Law and Social Justice in 2016 before moving here to Oxford in 2022. Iola's held visiting appointments in a very long list of leading institutions worldwide, including Copenhagen, the EUI, Harvard Chan School of Public Health, University of Hawaii, McGill University, Michigan Law School, Pompeu Fabra, Salamanca, Sciences Po Grenoble, and Wake Forest Law School. Iyiola has worked on EU law across her career. Her important contributions have included her leading text with CUP, now in the second edition, and her institutional work on the Court of Justice. However, a key theme in her work, which has intersected with her scholarship on the EU, but also gone beyond it, has been anti-discrimination law. She characterises her programme as being on institutional change, and in so doing, she writes as a legal scholar, drawing on a range of methodologies, historical, empirical, socio-legal, and political science, to address a series of related questions, some of which I'll now highlight. First, she's worked on how to understand the emergence of anti-discrimination law as a legal change and its ambition as a mechanism for social change in a comparative context. This was the topic of her first book, Making Anti-Racial Discrimination Law, a comparative history of the UK, Germany, and EU. Second, she's carried out a series of case studies of institutional change, or the lack of it, in particular contexts, especially the judicial institutions of the EU, highlighting the opacity of the appointment processes in the Court of Justice, resulting in predominantly pale appointees. Third, she's made a major contribution to thinking about how anti-discrimination law could best deliver social change. This was the theme of her important and ambitious 2017 book, Discrimination as Stigma, a theory of anti-discrimination law. It starts by articulating the limits in implementing anti-discrimination law as a list of discrete categories, and from there, she offers a normative account of how we could better characterise legally prescribed discrimination as stigma, that is, a negative labelling of an attribute which is supported and reinforced by power relations. A great strength of this focus on stigma is it highlights both the impact of discrimination on the individual and the social structures that enable it. As well as being outstanding scholars, we also expect our statutory professors to be leaders. Iyiola has shown and continues to provide tremendous leadership both within and across the academy. She undertook leadership roles for PG programmes within Leeds and latterly became the inaugural Dean of Equality, Diversity and Inclusion, leading, amongst other things, Leeds University's implementation of the Athena Swan. Across the academy, she founded the Black Female Professors Forum in 2017, an organisation for empowerment through collaboration amongst existing members and inspiration of current research students. This latter objective resulted in the remarkable OFS UK research-funded Generation Delta programme, which supports changes in admissions, support, mentoring, and progression in the postgraduate research lifecycle across partner institutions. Her appointment to Oxford has enabled Iyiola to continue to inspire by achieving two firsts, by being the first black and the first black female statutory professor in Oxford Law Faculty. And we're delighted that since she's joined us, she's drawn on the richness of her leadership experience to assist us through services as Associate Dean for Equality and Diversity in the Law Faculty and as a member of the faculty's mentorship working group, as well as leading the EU Law teaching group. She has since 2017 been an academic bencher at the Inner Temple and a judicial member of the Valuation Tribunal for England. She served as chair for the Commission of Inquiry into the History of Eugenics at UCL in 2018 to 19. The themes in Iola's research will, I think, feature in her lecture tonight, the title of which is Decolonising EU Law, Towards a Wiser and Wider European Union. Iyiola will speak for around 45 minutes, after which, as is customary, we will progress to the room next door for a drinks reception. Ladies and gentlemen, please join me in welcoming Iyiola Solanke, the Jacques Delors Professor of European Union Law.
Thank you, John. Thank you very much for that very kind introduction, and thanks to you all for being here this evening. Also, thank you very much to the Pro Vice-Chancellor, Jennifer Payne, for joining us this evening, to Molly Ross, the Bedell, for so amiably leading us to the hall this evening, and also to Tim Mawson, the Pro-Proctor. Before I get into the meat of my talk, I'd also like to just say a big thank you to the events team in the law faculty and also to the events team here at Somerville who have organised this event, and we wouldn't all be here without them. I'd also just like to say a huge thank you to all of my colleagues in the law faculty and at Somerville for just making me feel so welcome. I'm just at the start of my third academic year here, and I have to say I feel so at home already. It's just been a wonderful experience, and long may it last. So, this is my title for this evening, Decolonising European Union Law Towards a Wider and Wiser EU. What on earth am I going to talk about, you might be wondering? Well, as the Dean said in his opening remarks, I have a background of working in what we call equality, diversity and inclusion. Widening participation has been a strategic aim within universities for a few decades now, and we're all very familiar, I think, with the diversity agenda, which incorporates all of those characteristics which alone and in combination are set out not only in UK but also in European Union anti-discrimination law. It's almost part of our everyday business now in higher education. But my aim in this lecture is to explore how this goal of widening participation can be used beyond higher education and beyond the UK and applied to diversity in European institutions. Now, as John said, in the past I've written about diversity in the European Court of Justice. That's my support out there. In the past I've written about diversity in the European Court of Justice, but this evening, I'm going to think about diversity in the European Commission and how these ideas can be used to achieve a wider representation in the European Commission. I'm focusing on the European Commission due to the breadth of its tasks. These are set out in European Union law. It's considered to be the key institution in the EU. Indeed, it's known as the guardian of the treaties, because it's responsible for such a wide range of tasks, including initiating new European Union law, as well as taking to task those member states or institutions that fail to abide by European Union law. It also delivers the European Union Work Programme and oversees the budget, as well as membership of the European Union. In addition, it conducts research, investigations, and makes key decisions in relation to legal, social and political integration in the European Union. So diversity is important in the European Commission for the same reason that it is important in all organisations. As has been said, diversity, both cognitive and cultural, often leads to better questions, better analyses, solutions and processes. It's now broadly agreed that a broad range of views can discover better answers for a complex world and produce stronger solutions. In particular, in relation to a lawmaking and enforcement body like the Commission, to adapt a statement made by Lady Brenda Hale, the first female president of the United Kingdom Supreme Court, European Union law, the European Union legal profession, and the European Union courts are there to serve the whole population, not just a small section of it. They should therefore be as reflective of that population, the commissioners that is, should be as reflective of that population as it is possible to be. Diversity will improve the legitimacy of the Commission and by extension that of the European Union as a whole. Now, the diversity agenda is not unknown to the European Commission. Many years ago, it created a pan-European scheme of diversity charters encouraging private and public bodies across the European Union member states to promote diversity and equal opportunities for their staff. However, it seems that the Commission has forgotten to apply this to itself. As Shada Islam, a journalist, said, look at this photo of Ursula von der Leyen's new team and tell me the European Union doesn't have a diversity problem. As you can see, gender diversity is not the issue. There are many women in this picture, including the President herself, Ursula von der Leyen. Now, at Somerville College, one of the original so-called ladies' halls in Oxford, we fully approve of this. Somerville was founded in 1879 as a non-denominational hall for women and named after Scottish mathematician and renowned scientific writer Mary Somerville. The founders wanted the hall to embody the virtues of liberalism and academic success. Mary Somerville was chosen by the founders as the person to give her name to the college due to her scholarship, as well as for her religious and political views, especially the conviction that women should have equality in access to education and the right to vote. Somerville defended the right to equality for all women. A student from India came to Somerville in 1889, just 10 years after the college was founded, and Cornelia Sorabji, who you can see here in her legal dress, was also the first woman to study law at Oxford. Cornelia Sorabji was a pioneer in so many ways. She was the first woman to graduate from the University of Bombay, and the first woman and the first Indian to read the BCL in Oxford. She was also the first woman to practice law in India. She worked for many years as a legal advisor to women and children on matters in provincial courts and as a lady assistant to the Court of Wards. She finally became qualified as a barrister when women were admitted to the profession for the first time in 1923. So at Somerville, we loudly applaud the European Union for having a woman at the helm in the European Commission, indeed for 2 terms. But in the 21st century, are all the women white? It appears that there are no racially minoritized women, or men for that matter, in this picture. I'm sure I can speak for my fellow Somervillians and say that we do not approve of that. We may have gone mixed in 1994, but we continue to hold on to our key foundational principles. First, of welcoming those of faith and those of none, and second, to resist mandatory perspectives. In this case, the lack of diversity at the Commission leads me to question whether this is manifestation of a mandatory Eurocentrism. Is an unthinking commitment to Eurocentric logic leading the Commission to overlook the need to reflect Europeans in all of their diversity? Black French, Black German, Black Italians, Black Spanish, and Black Swedes, and so on. Clearly no longer Black British, but never mind. We won't go into that this evening. Is there a belief in the Commission that all Europeans are white? Well, we know that this is not so. Professor Olivette Otele reminds us in her book African Europeans that long before Cornelia Sorabji arrived in Somerville, there were black people in Europe, including the first Duke of Florence, Alessandro de' Medici, who, according to the American Public Broadcasting Service, was the first black head of state in the modern Western world. Indeed, Otele presents evidence in her book to show that by the 16th century, there was a sizable black population in southern Europe. Some were free, but in Renaissance Europe, the majority were enslaved. 500 years later, in the 21st century, black Europeans are no longer traded, but it seems forgotten. So what I want to suggest in my talk this evening is that in order to address this lack of diversity, Eurocentrism in the Commission must be taken to task. This requires, as put by my colleague Professor Liz Fisher, taking a thicker approach to diversity that emphasises knowledge production and knowing, re-evaluating what is understood as reliable knowledge and acting on that understanding by fostering more diverse communities. In order to develop this thicker approach to diversity, I will set the agenda within decolonial theory. Now, decolonising is distinct from diversifying. Diversity is only a part of the decolonisation agenda because it can still exist within a Eurocentric or Western bias. It can, for example, only focus on white women in relation to gender, as we see in the Commission. Decolonisation attempts to go further and deeper in challenging institutional hierarchies and monopolies on knowledge, and therefore has more profound implications. So in my talk this evening, I plan to explore how a decolonial approach can disrupt Eurocentrism in the Commission. Now, I realise that to describe the European Commission as Eurocentric may sound like a contradiction. But as Martin Hesselink at the European University Institute points out, this is only from a Eurocentric point of view. After a few biographical words in part one of my talk, part two will explain coloniality and decolonial theory. And then in part three, I will elaborate upon the relevant decolonial principles and practices that I think can be used to create the foundation for a wider and wiser European Union. So, a few biographical details. So, this is my mother on the far left and my elder sister. I'm a Londoner. I was brought up by my mother, Iyiola Solanke, in a multiracial and multicultural corner of West London. And here she's sitting with my sister, who's actually also here at the front, who, as they prepare to go out for a dinner in London. My siblings and I, we all attended state schools. I was very fortunate. I sat in a class that was like a mini United Nations. Like Cornelia Sarabji, all of our parents had arrived in England from the British colonies, and we were part of the growing population of black and minority ethnic Britons. I remember my school with fondness. In particular, I remember my form teachers, including one Mr. Löwenstein, who was my first form teacher when I arrived at age 11. He was then a newly qualified teacher, and we were his very first class. And he still knows all of our names by heart. He's sitting at the back, and if you were to ask him to cite the names of all of the students in his class, he would still know them. We've tested him on this. He was the best type of teacher that children at age 11 could ask for. He was the type of teacher who would laugh, even though he tried not to, at all of our naughty antics. We were a group of very boisterous inner city students. I stayed at school for sixth form to complete my A-levels, and then left, as the dean said, to study German and drama at Goldsmiths. This took me to a small city in Germany called Tübingen, where I spent my Erasmus year. And during that time, I found a couple of books that changed fundamentally my understanding of Europe. So these two books on the right are actually the same. In the middle, you have the German title, and then on the far right, the English translation. Farbe bekennen means showing our colours. I was amazed during my Erasmus year to discover that they were black Germans. Nobody had ever told me this. And this simply made Germany much more interesting as a country. And it actually made Europe much more interesting as a continent. I suddenly started to wonder, my goodness, if there are black Brits and black Germans, maybe there are black French and black Spanish, black Italians, indeed black Europeans. And to be honest, I think my academic career began with this discovery. Now, another book that I came across was sadder. The book on the far left is called Tadesse Warum, meaning Tadesse is the name of a child, Tadesse Why is the title, and it's the very sad story of a young Ethiopian boy who was adopted by a German family and at the age of, I think, 11, killed himself. So the book is asking Tadesse, why did you do this? And that also really touched me and started me to ask the question as to why is the Black German experience so different to the Black British experience? And that, as the Dean said, has really been a question that has accompanied me throughout my academic career. I started off thinking about it from a social policy perspective, but ultimately ended up in law. I wrote a PhD thesis in law, so wonderfully supervised by Professor Nicola Lacey and Professor Damien Chalmers, who isn't here. I wrote a PhD on the evolution of anti-racial discrimination law because I wanted to understand how the law affected the life and experiences of Black Europeans, but also whether the Black experience in Europe affected the life of the law. And I remain interested in such questions. My research revolves around issues of social justice, of equality, and of course, European Union law. And that is what brought me to decolonial theory. Decolonial theory is not a new idea. Chinweizu wrote in 1987 about decolonizing the African mind. But I would argue with recent political events, this theory is of its time. It may not be an exaggeration to say that we are entering an age of disruption, a new world where disruption is the name of the game. In this sense, decolonial theory is like artificial intelligence and Spotify. It aims to disrupt, in this case, euro-centrism and unthinking reproduction of power hierarchies associated with coloniality. As with all disruption, decolonial theory brings the good, the bad, and perhaps even the ugly. There is indeed a dark side which has seen it used for negative ends. But let's start with the good. In the best academic tradition, decolonial theory demands the discovery of new knowledge, making new links and dismantling traditions that are no longer purposeful. The theory targets coloniality. Now, coloniality goes beyond colonialism. While colonialism is linked to specific places and times, coloniality is a broader analytical framework which describes long-standing patterns of power that emerged as a result of colonialism. Maldonado Torres argues that these patterns may be historical, but still exert a power to define culture, labour, interpersonal relations, and knowledge production, well beyond the strict limits of the colonial administration. Coloniality, therefore, refers to the ongoing impact of colonialism, a continuation of colonial ways of thinking and knowing that spread across former colonized territories through the universalization of Western norms and values. It could be said that coloniality drives mandatory Eurocentrism. Decolonial theory has been given a pedagogical nuance. I expect by now most of us are familiar with the idea of decolonizing the curriculum or decolonizing even the university. And this refers to the process of identifying where and how coloniality has left its mark on knowledge systems and practices of knowledge production by imposing this lens that universalizes the European experience and devalues practices of knowing and knowledge from other parts of the world. In the context of higher education, decolonial theory sits alongside artificial intelligence in challenging we higher education practitioners to rethink and reconstruct norms. As put by Professor Alpeshah, who was appointed chair of anthropology, the statutory chair of anthropology here at Oxford, decolonial theory brings a critically needed democratizing energy, sentiment, and spirit to the university and academic disciplines. Now, the idea of decolonizing European Union law in particular is still very young. I see this as an exciting approach which can help EU law to shake off its commitment to colonial ways of thinking, i.e. mandatory Eurocentrism. For example, the common sense idea that all Europeans are white and black Europeans are really from somewhere else. Perhaps most importantly, a decolonial approach in European Union law can open up the world of European integration to a new generation of scholars and audiences who have hitherto not engaged with this area of study due to the dominance of Eurocentric perspectives. One downside is that decolonising has become a buzzword. According to the British Library catalogue, the same number of books on decolonising, 73, were published between 2014 and 2018, as in the 20 years between 2014 and 1994. Worse still, decolonial theory can be used by political movements to promote a kind of originalism, a return to a golden age. Obafemi Taiwo, in Against Decolonisation, writes about originalist political movements that divide culture into bad European and good African, for example. This simplistic approach is described by Professor Alpashar as a hijacking of the decolonisation agenda, as she writes she has seen happen in India, where it has been deployed against oppressed groups to support populist political movements. As Taiwo Obafemi notes, transforming the campaign against coloniality into a call for renouncing any aspect of the cultural, social, political, or scientific life of the colonizer would be to give up on the very oneness of humanity, the ultimate racist trope, and the fact that hybridity is the very core of human civilization. So there is no one way to decolonize. Although always directed to disrupt coloniality, this can manifest in many ways depending upon the strategies required by the context. And you have this very long quote on the screen here from Foluke Adebisi, who wrote this wonderful book, Decolonization and Legal Knowledge. And she says that we should understand that decolonization is not one thing, but a set of context-dependent strategies adopted by peoples resisting all forms of enduring colonization. Strategies specifically relevant to the particular ways in which colonial ideologies manifest themselves in those particular places. In other words, decolonization in practice has often involved indigenous peoples, colonized peoples, racialized peoples, and their allies taking up the tools that they have to resist specific forms of oppression that they experience in the places where they experience it, at the time they experience it. For them, decolonization is a tool to make their futures possible, livable, and flourishing. What then is the context in the European Union? And what tools do decolonial scholars have? For today, I will focus on 3 specific aspects of Eurocentrism and 2 specific decolonial tools. So the first context is, as previously mentioned, an institutional one, the composition of the European Commission. It simply does not reflect the population that it exists to serve. Now, by the way, I should remind you that the same applies to the other EU institutions. As I said earlier, I've written on the lack of judicial diversity in the Court of Justice. A second area is European Union internal market law and policy, in particular European Union law on refugees and asylum seekers. Whether they be students fleeing war in Ukraine or families crossing the Mediterranean Sea in small boats. I have argued that the treatment of African and Asian students fleeing war in Ukraine is a manifestation of coloniality. These students were held up at gunpoint, arrested, and placed in detention centres when they tried to seek safety. They have been given very little support to continue their studies. This behaviour by national border guards was sadly in line with the general European Union response. Rwanda-style plans with Albania to deport asylum seekers to third countries, the use of naval blockades to stop migrants fleeing North African countries, and pushbacks in the Mediterranean by Frontex, the European Union border agency. These all stem from a certain way of viewing people seeking safety, the majority of whom are racialized and from formerly colonized countries. But such responses reflect more the dehumanizing values embedded during colonialism than the humanitarian values currently espoused in the European Union treaties and in the European Union Charter of Fundamental Rights. Other examples, which I won't discuss in more detail, are in the area of external action, such as the complex area of data governance. Kenya is just one country which is being encouraged to incorporate the European Union GDPR into its national legal framework, although Kenya played no role in its adoption. As Kivers and Ouma point out, is this helpful? Or does usage of the European Union model in Africa simply transfer colonial pitfalls that would be best avoided on that continent? EU fisheries policy is another example. It's ironic that overfishing by European Union boats off the coast of Africa is fueling migration to Europe, because it is depriving, these European Union boats are depriving small-scale African fishermen of their livelihoods. Now, the subsidies paid to West African countries under the European Union Common Fisheries Policy have been found to drive overexploitation of fisheries and unemployment of local fishermen. So what decolonial principles and practices can help address Eurocentrism in these contexts? In previous talks and papers, I focused on principles such as democracy and intentionality. However, this evening, I'd like to suggest a further one, which is conviviality. Francis Nyamjo defines conviviality in terms of scholarship. He says that a truly convivial scholarship is one that does not seek a priori to define and confine Africans into particular territories or geographies, particular racial or ethnic categories, particular classes, genders, generations, religions, or whatever other identity marker is ideologically en vogue. Convivial scholarship, he says, confronts and humbles the challenge of over-prescription, over-standardization, over-routinization, and over-prediction. It is critical and evidence-based. It challenges problematic labels, especially those that seek to unduly oversimplify the social realities of the people, places, and spaces it seeks to understand and explain. Learning that applies the principle of conviviality therefore promotes ecologies of knowledges rather than a single way of knowing. Now, whilst the European Commission is not an institution of scholarship, this principle should apply to the Commission because of its crucial role in making European Union law. It is not just a technocratic body. As mentioned earlier, it creates proposals and drafts and works on amendments with the other lawmaking bodies. By reminding us to take a step back and question our assumptions about knowledge production and ways of knowing, conviviality, applied conviviality, can highlight and disrupt Eurocentrism. Application of this principle could therefore make the Commission wider and wiser. The principle could produce an institution of lawmakers that better reflects those it serves, and perhaps even a field of scholarship that is more inclusive. So conviviality emphasizes curiosity rather than closure, acceptance rather than confrontation, and humility instead of simplification and categorization. As Nyamjo says here, convivial scholarship does not impose what it means to be human, just as it does not prescribe a single version of the good life in a world peopled by infinite possibilities, tastes, and value systems. So I think it's clear to see how this principle could result in greater diversity in the Commission. A convivial Commission would see and do things differently. It would immediately see and be appalled by the lack of diversity in its ranks. Furthermore, it would recognise the impact of this on its institutional wisdom across the member states. It would acknowledge and promote acceptance of the reality that black people in Europe are also European. In seeking to improve wisdom across the member states, a convivial commission would also seek to shift the conversation on the collection of racial data. Across mainland Europe, unlike in the UK, the collection of disaggregated race and ethnicity data for law and policy making is very limited. So a convivial commission would identify the omission in its own ranks and rapidly take action to address it. In order to understand the full variety of lived experience across the European Union, it would also take steps to decolonize the conversation on the collection of racial and ethnic data. Collection of such data would widen the European understanding of its population, making it wiser in the formulation of EU law and policy. Now, in relation to asylum law, how could conviviality help us? Well, I would say that conviviality also includes remembering and promotes remembering as integral to knowing. What is remembering? Professor Peter Mosier, Sub-Dean at Christ Church College, said in his sermon on Remembrance Sunday that remembering and memory are two different things. We remember those who have died in the world wars, even if we have no personal memory of these events. He suggested that we pull the word remembering apart to talk about remembering, putting back together the separated fragments, the bits, so that they make a whole that can make sense and can have something plausible to say to us here and now. So when we remember the two world wars, because of the enormous scale of the events, there are literally millions of fragments to assemble, to remember. But what do we get when we put them together? An affirmation that at all costs, evil must never be allowed to triumph in the affairs of nations. That we must hold fast to the truth that God has not created some people and some races superior to others, and that fighting for these values is immensely costly in terms of human life. And so Remembrance Day points on the one hand to thanksgiving for those who suffered and died in these causes, but on the other hand to a renewal of our own resolve to overcome evil in the world. And he concluded, we must remember because if we give up on remembering, then we're in danger of forgetting those basic values and ignoring what we need to learn from history and from the errors of the past. And God knows, we need that more than ever in the current global situation. In addition to these public anniversaries across Europe, remembering is also encouraged by the many monuments focused on war. Remembering those lost at war can be described as a backdrop to life. Now, when we remember these wars, we should also include the fragments of the lives lost by colonized peoples during World Wars I and II. These include the African men who fought in colonial wars across Africa, or the many men from around the world, and you have some of the numbers on the screen in front of you, who saw active service in World War I. Now, while racism may have informed the use of colonial troops, there were complaints from the Kaiser in Germany that warfare was being made uncivilized by incorporating racially inferior warriors. Racism should not have any part in remembering in the 21st century. As put by Daz, the lives of hundreds of thousands of women and children in villages across Asia and Africa who lost their husbands, brothers, or fathers and faced different kinds of hardships remains one of the most silent and under-researched areas in the First World War history. To repeat the words of Reverend Mosier, we must remember because if we give up on remembering, then we're in danger of forgetting those basic values and ignoring the need to learn from history and the errors of the past. Valuing the role played by colonized countries during past wars could have a practical consequence in shifting the conceptualization and the tone of conversation today on refugees and asylum seekers in European Union law and in the European Union in general. As I've said, currently the political and public conversation seems to be grounded in the kind of colonial discourse that sees continents such as Africa and Asia as backwards and their peoples in the same way. By remembering the Commission, this will help the Commission to avoid repeating mistakes of the past in the 21st century, although sadly it may have already fallen into this trap. So the European Union has just agreed a new asylum compact, which establishes for the very first time a centralised biometric database for asylum seekers. It's called Eurodac. This repeats the method of biometric registration used in the colonies and indeed during the transatlantic slave trade. As Lawrence Meyer laments, it's just a continuation of this draconian history when technologies were developed to mark, identify and track people as captives and properties in order to guarantee order and continuity of the colonial regime. Other types of remembering are also possible. This can include institutional inquiries, such as that conducted at UCL or other universities in the UK and the USA, or by the Church of England, indeed, into Queen Anne's Bounty. Exhibitions are further examples of remembering, curation being quite literally the act of collecting and collating fragments to create a new or counter-narrative. An example of this is the exhibition in Portugal, focusing on the human cost of its colonial and slave trading past. Or the exhibition in the Netherlands, bringing together the remaining fragments of the life of a little-known anti-colonial campaigner from Suriname, Anton de Kom. So to summarise on decolonial principles, the principle of conviviality highlights and disrupts Eurocentrism by excavating coloniality. A convivial commission would see differently and act to promote diversity in its ranks and in its knowledge production. A convivial commission would also practice and promote remembering within the commission and across Europe, supporting excavation and dissemination of such information. This would, as Obafemi Taiwo says, take the agency of the Global South seriously and disrupt coloniality in discussions of refugees and asylum seekers, piercing the current negative narrative to provide an antidote to Eurocentrism in EU immigration and asylum law. So then to think about decolonial practices. In previous talks, I've emphasised the need to focus on questions of omission, who is missing, on methodologies such as co-production, and on empirical study, as key practices informing a decolonial approach. This evening, I will focus on another practice, cognitive justice. The starting point for cognitive justice is epistemological. Now, an episteme refers to knowledge and understanding, an intellectual atmosphere. Epistemic injustice therefore refers to the creation of an intellectual atmosphere where social power is used to ensure that the knowledge of some groups is excluded from the collective epistemic resources. This is a wrong done to somebody specifically in their capacity as a knower. Miranda Fricker has written this wonderful book on epistemic injustice. And in this book, she explores power and the ethics of systems of reasoning and knowing. Her work highlights how persons are wronged in their capacity as knowers, as beings who know but are seen as not knowing, nor having social experiences worthy of being known. This situation can arise by preventing or making it difficult for particular knowers to know what it is in their interest to know. In a significant departure from traditional philosophy, Fricker argues that even reasoning as an epistemic practice is entangled with social power. Her goal is therefore to analyse how social power operates in order to reveal epistemic injustice as a potent yet largely silent dimension of discrimination. She describes two kinds of epistemic injustice: testimonial injustice and hermeneutical injustice. Testimonial injustice, she writes, occurs when prejudice causes a hearer to give a deflated level of credibility to a speaker's word. For example, if the police do not believe you because you are black. We might say that testimonial injustice is caused by prejudice in the economy of credibility. An example of testimonial injustice can be seen in the treatment of African and Asian refugees fleeing the war in Ukraine. As I said, these students were not only denied assistance to flee afforded to white Ukrainian refugees, but also the protection, care and hospitality afforded to white Ukrainian refugees under European Union law. Due to epistemic injustice, they had a deflated level of credibility. While testimonial injustice is individual and behavioural, so it happens on an interpersonal level, hermeneutical injustice is social and structural. It arises because a hearer lacks sufficiently shared concepts with the speaker to reach a common understanding. And this type of injustice will persist despite the will or efforts of the speaker to enable understanding. Hermeneutical injustice precedes testimonial injustice. It occurs, Fricker writes, at an earlier stage, when a gap in collective interpretive resources puts someone at an unfair disadvantage when it comes to making sense of their social experiences. For example, she writes, if you suffer sexual harassment in a culture that still lacks that critical concept. Hermeneutical injustice is caused by structural prejudice in the economy of collective hermeneutical resources. An example of hermeneutic injustice arose in 2022 when Josep Borrell, the High Representative of the European Union for Foreign Affairs and Security Policy, and also a Vice President of the European Commission, described the European Union in terms of a garden versus the jungle outside. Thankfully, Borrell was strongly criticised. Professor Jan Orby wrote that the EU should be more modest about its so-called civilizational achievements and acknowledge the long and dark shadow of the colonial past. The inability of the European Union of the European Court of Justice to understand intersectional discrimination might also be another example of hermeneutic injustice. In these cases, the Court of Justice was silent on intersectional discrimination, perhaps because this experience simply lies beyond the collective epistemological resources available in that institution. So Fricker's work highlights the link between epistemic injustice and injustice in practice. In the context of higher education, decolonising the curriculum is indeed a demand to end epistemic injustice. Replacing epistemic injustice with cognitive justice is therefore a core purpose of the decolonial agenda, to change ways of knowing and seeing and who is recognised as a knower. But what does this mean in the context of the European Commission? Well, the way forward from Eurocentrism is, I would argue, epistemological, in particular replacing epistemic injustice with cognitive justice. The Commission, because it's the body to initiate legislation in the European Union, should indeed champion cognitive justice. And in championing cognitive justice, this can help create diversity in the Commission and improve internal market law, in particular EU asylum and refugee law. So I would argue that the lack of diversity is a per se manifestation of an unjust intellectual environment or epistemic injustice. And it would be a very laudable and practical task for this newly appointed Commission to remove Eurocentrism by championing cognitive justice. As a first step, the Commission would need to acknowledge the omission, to identify what is missing from its ranks, and then to value the importance for its work of the presence of a multiracial range of knowers. A convivial commission would readily do this. The next step is perhaps more difficult. Where are these multiracial knowers of European Union law? In many respects, the field of EU law and European Union studies reflects the Commission. They too are Eurocentric. The European Union law canon tends to see only the lives and concerns of white Europeans in terms of who enjoys the privileges of European Union law. Perhaps as a consequence, the field is racially homogenous. As I have highlighted in the past, there are too few black professors in Europe, and more specifically, too few in European Union law. So to champion cognitive justice in the Commission, it will be necessary to nurture more diversity in what is studied under European Union law, as well as who studies it, who teaches it, who manages and leads research in the field and in EU studies more generally. As Professor Liz Fisher points out, this cannot be done overnight. It takes time, but the Commission can make a start. This is a new Commission just about to begin a 5-year term. If it commits to champion cognitive justice now, we may see improvements in diversity of the next Commission. What would it then mean to champion cognitive justice in relation to refugee and asylum law? Well, to do this, the Commission, as I've said, would widen the pool of valued knowers and valued knowledge in the traditional narrative on the evolution of the European Union. The grand narrative of European Union integration is generally told in a way that excludes both the peoples and the parts of the world that were colonised, even though we know that when the Treaty of Rome was signed in 1957, and this map from 1958 shows that very clearly, colonies were a reality for 5 of the founding member countries, and of course Luxembourg benefited indirectly. France still had a number of possessions across West Africa, as well as in Asia, the Caribbean and the Pacific. Belgium ruled over Zaire and held trusteeship of Rwanda, Burundi. The Netherlands still had its colonial territories in the Pacific and the Caribbean, and Italy had a mandate over Somalia. Only Germany had no colonial connections anywhere in the world, having lost control over these as part of the post-World War I settlement in Versailles. Now, these colonised countries were integrated into European Union law under Articles 131 and 136, which set out the idea of associationism as a method to manage relationships between the European Economic Community, as it then was, with these countries. Now, cognitive justice would require excavation and dissemination of this violent period in European history. The former colonies would be studied and researched as integral to understanding the foundations of the present-day European Union. What is known, for example, if anybody from these colonised territories participated in treaty negotiations? Did any women play a role? How might independence movements have influenced debates on European integration? Did colonialism itself shape European consciousness? Like Josep Borrell, did European leaders use colonised lands to create a self-understanding as the basis of the foundations of the European Union legal order? Questions can also be asked of practices in the European Union institutions. Are there any processes or conceptual designs that were transferred from the colonial territories to Brussels and Luxembourg? A commitment to cognitive justice would seek to answer these questions and thus widen the knowledge that is valued in understanding the evolution of the European Union and European Union law. It would create space for stories on the lives of European unions, which are only seen sporadically in the cinema to be discussed in the classroom. I'm thinking of films such as Mother and Son or Beautiful, stories of black Europeans and migrants that we do not study, although they are integral to European integration. By excavating this knowledge, the Commission would identify non-Eurocentric her, their, and histories to broaden the tale it tells about the evolution of European integration and European Union law. Excavation is important because it creates the knowledge basis for the Commission to move towards cognitive justice. As stated by Professors Miller and Nicola, the failure of legal scholarship in general to pay attention to the role of Europe's colonial past in Europe's present has consequences for knowledge production in Europe. In broadening its knowledge, the Commission creates a wider and wiser source upon which to inform EU law and policy. This will help to ensure that its proposals do not embed tropes and practices which firmly belong in the past. Now, some European Union law scholars are already conducting this work and seeking to make space on the core European Union constitutional curriculum to include such material by, for example, using case law on immigration and asylum to illustrate core European Union principles, European Union law principles, such as direct effect. So to summarise, cognitive justice in the Commission would broaden the intellectual environment in which European Union law and policy is designed by nurturing a new core of knowers and excavating the imprints of colonialism in European Union law to create new knowledge. So you'll be happy to know I'm slowly coming to my conclusion. Einstein is reported to have said that the clever person solves problems, but the wise person avoids them. So I've discussed how decolonial theory can help create the foundation for a wider and wiser Commission, and thereby a wiser and wider European Union. I explained decolonial theory and coloniality, the idea that a legacy of relations and systems established under historic colonialism persists in the current day, both within nation states as well as between them. I should stress that I am not suggesting that European integration is a colonial project. Let us remember that colonization was a brutal system of conquer, kill, divide, and rule. The process of European Union membership is very different. States apply to join and participate as equals in rule-making and law enforcement. There was no such choice under colonialism. What I am suggesting is that the legacy of colonialism, coloniality, can be seen in aspects of European Union law. Now, when I think about it, this is probably a very obvious point, because like the Westphalian state system, colonial systems also survived European integration, as we see in this map. The European Economic Community was built upon existing imperialism. Colonialism was directly imported and structurally maintained during the process of European integration. European Union law embedded into the treaties the prevailing asymmetries of power between the colonized countries and the colonizers, ultimately institutionalizing at a regional level the relationships prevailing at the national level. I discussed two ways in which decolonial theory can help to tackle this Eurocentrism. First, by emphasizing conviviality instead of conversion in knowledge production. And secondly, by replacing epistemic injustice with cognitive justice. In the age of disruption, conviviality and cognitive justice are therefore useful concepts to anchor in the European Commission, given, as I've said, its role as a source of information and knowledge that goes into making and enforcing European Union law. By incorporating these into the foundations of European integration, the Commission can create the foundations of an inclusive internal market. Finally, it's worth considering why the Commission should care about Eurocentrism. What is the cost if the Commission just ignores this? I would say this needs to be addressed because, like colonialism, Eurocentrism is not benign. It has significant long-term consequences for first the character and second the quality of democracy in the European Union. Mandatory Eurocentrism, an unthinking commitment to Eurocentric logic, restricts the development and dissemination of alternative ways of seeing that may be needed to both avoid problems as well as solve them. It thus destroys the character of democracy by embedding blinkered intellectual decision-making practices. When the character of democracy is damaged, the quality of democracy suffers. The increasing popularity of the right wing across Europe, especially amongst the young, indicates that the quality of democracy is being undermined. A weakened democracy damages European Union credibility, especially at this point as it tries to be a force for good and have greater impact in the world. A weak internal European Union is a weak external European Union. So addressing Eurocentrism can avoid damage to the character and quality of democracy in the European Union and ensure its continued relevance in an increasingly unstable world. Thank you for your attention. I think we all deserve a glass of wine.